My name is Sanjeev Bajwa, and I'm a patent attorney and founder of Luminate IP Solutions. We focus on securing patents and trademarks for clients, which include large and small technology companies that implement AI. So today we'll be discussing AI in specific areas pertaining to criminal justice and privacy. Now, before I start off the discussion, as a patent practitioner, many times I work with data scientists to get their inventions patented. And many times we start with the data set that's used to train the AI model. So one of the questions that always seems to be overlooked, or maybe it's not the correct place for what I do, but maybe as data scientists, you maybe should start thinking about this, is whether the data set that's actually being used for your models is appropriate. Like what types of data should be used and what types of data shouldn't be used and why. So those are the types of questions that we are going to be looking at. We're also going to be looking at what role does privacy rights factor into this? Like what individual privacy rights do people have? And what are those expectations for privacy when it comes to things like social media, as opposed to things in terms of the criminal justice arena? And so lastly, we're going to transition to discussing the various ways that AI is being used in criminal justice right now and some of the challenges with those uses. So I'd like to start off by introducing our panelists today. So first we have Joe Omoraku. Did I pronounce that correctly?
Perfectly good, yeah, thanks.
Okay. Joe is a corporate attorney specializing in compliance and privacy and risk management. His current role as head of corporate compliance and ethics, and as well as a data protection officer. Joe has led the establishment of the Compliance, Ethics, and Privacy Group at Lidl US, which is the 4th largest retailer in the world. In addition to being an attorney, Joe is also a certified privacy professional and a compliance officer, as well as a fraud examiner. So I think we got the right guy for privacy on our panel today. We also have Preeti Bajwa. She's an attorney at the California Attorney General's office, where she practices complex civil litigation in the field of correctional law. Prior to joining the Attorney General's office, Preeti was a criminal defense attorney working at the public defender's offices in Santa Clara County, as well as Sacramento County, as well as being a criminal defense attorney in private practice. We also have Ian Ferguson. Ian is a business systems analyst for the district attorney of San Luis Obispo County. Ian is in charge of assessment, development, and implementation of technology tools within the DA's office. And lastly, we have Will Ferrier, and he works for the Yolo County District Attorney's Office here in California. Will is the chief of the Yolo County Innovation Division, where he focuses on driving efficiency and continued transparency between the DA's office as well as the community. In addition to his role in the Yolo County DA's office, Will has advised and co-founded various startups. So I'd like to jump right in, since we do have a short time frame here. So Joe, if you could just start us off by giving an introduction to privacy and how privacy works and what rights do individuals have, and how that interacts with the data that's collected for many models.
Perfect, happy to do that. I think in some ways I've got the easy straw out of the panelists, maybe to start with what I think a lot of people probably do know, but a good base position, and then we can work the conversation from that point. So I think it's important to have a conversation about, what is the standard data set we're normally working on? And I guess, especially for those folks who are going to take part in the hackathon tomorrow and see this as a kind of a part of a learning strategy. Your standard data set comes from commercial records that were voluntarily provided when somebody bought something, public records that are available, let's say, records are gathered through e-commerce, your kind of standard digital combination of various different sets together, and our kind of basic concept that I'm sure most of the listeners are very familiar with. So, your kind of best practice, your key pillars, the idea of that you have some kind of notice, that you understand what it is you're consenting to or what's going to happen. That of course you have a choice. You're not forced to give the data. It's a choice you make, let's say. that there's some kind of aspect of security, that there's some effort made to at least, you know, secure that data with whoever is collecting it, you know, kind of access control, that it won't be maybe given to everybody. Again, that's distinct from if you're publishing something on social media, let's say, but you know, in your normal scenario, there's some kind of access control or access rights kind of there. The other one then, kind of a bigger topic in the last years, is kind of purpose limitation. So this idea that, well, I gave it to you for this reason, and that's what I assume you're going to do with it, and that's kind of what I consented to. Interesting one, because it's quite different between Europe and America, but we can come back to that later. And then obviously then the final one from your kind of key pillars of data privacy concepts is maybe concept of accountability for onward transfer. That I have this data, but then if I hand it on to somebody else, what might they do with it? And you know, I still have that accountability back for that promise ultimately that I made, you know, when I gave the notice in the first place. So in a lot of ways, you know, it's kind of really important to think about it. You know, we think we have a right to privacy, and certainly in Europe, you know, it's a fundamental human right. You know, quite spelled out. Different history and culture there, of course, but you know, that led to that belief. But it's important to remember that, you know, the word privacy doesn't appear in the U.S. Constitution. You know, it is not there per se. You know, of course, we all have a right to privacy, and that came, I guess, you know, the Fourth Amendment kind of more reasonable concept of kind of a unreasonable search and seizure that people would be more than familiar with. And then obviously the Griswold case later in the 60s, kind of this idea of that you have a, you know, reasonable expectation of privacy. And I can see how that made sense at the time, but that's the crux of it. What does reasonable mean? And I think, you know, a lot of folks, you know, who are used to working with a data set, data analysts, data scientists, that reasonableness is often spelt out quite clearly, you know, when you look at, well, what notice was given when the data was collected. If you voluntarily gave the data and you read the notice, or at least the notice was available to you, then, you know, whatever was said in that notice, that's what you reasonably expect to happen. Maybe a kind of a simplistic example might be, you know, if you walk into a store, you probably have a reasonable expectation that there will be CCTV recording in that store. You definitely have a reasonable expectation if there's a sticker on the door with a camera sign or CCTV recording in here. But you know, and that makes sense. I mean, that's pretty clear. But you wouldn't obviously have a reasonable expectation that there'd be cameras in the toilets or something kind of, you know, way out there. Obviously, then, you know, the issue here becomes that it's not these basic data sets that we're talking about in the scenario for these conversations today. Instead, it's kind of an amalgamation of things that are public record, things that are available, maybe information that was given over voluntarily, and I'll let some of the colleagues talk about that a little bit more. But also things, and it was really interesting, the previous panel immediately before us, Elizabeth mentioned Ring community in particular, that it may have been handed over voluntarily, but not necessarily by you, by your neighbor or somebody up the road. And then obviously, yeah, the third party sets. So obviously, at this point, it makes more sense to hand over to Preeti to get into a little bit more detail. Obviously, you know, if we're looking at government action, you know, it must be something that's considered to be a search. And then we're back to that main point again. What is reasonable? You know, we all have a kind of our simplistic ideas of probable cause, you know, somewhere halfway between suspicion and proof. And I guess at that point, I'll let Preeti take over to take this a little bit deeper into the world of criminal justice and out of the basic, maybe more corporate data sets that some of our watchers might be more familiar with.
Great, thank you, Joe. Yes, so I think a good place to follow up, Joe, from where you're at is, you know, what is considered reasonable in a criminal setting. As the courts have described it, that the seminal case is Katz, and it's followed up by Berger. But in Katz, really the question that was posed is whether there's a reasonable expectation of privacy, and it's a matter that is determined on a case-by-case basis and is very fact specific. So in Katz, the focus was regarding electronic surveillance, and the court said that to the extent that a person has a reasonable expectation of privacy in what they're engaging in, the activity they're engaging in, and it seems reasonable to society's norms, that would be reasonable. Now, taking the example that Joe gave us of if you walk into a store and there's CCTV going on and you've been put on notice, obviously, if you shoplift something, that's going to be recorded on camera. Your reasonable expectation of privacy is gone. And you're also in a public space, right? But what if you are a guest in somebody's home, right? The house obviously is inherently sacred, and the courts have held that. So as a homeowner, you have an expectation of privacy. The police cannot come into your home without a warrant. However, if you are a guest in that home, you do not have a reasonable expectation of privacy in that home. So if you're engaging in criminal activity, you've got some drugs there or whatever, cops come in with a warrant, or the owner of the house consents for them to search his home, anything that they find that's your property in the guest bedroom that you're staying in, you don't have an expectation of privacy there. And then the other point that I wanted to touch on, which I think is relevant to our discussion today, is this idea of third party and giving consent to third parties to that by giving consent to a third party, you've given up your privacy there. Most recently in a case Smith, the court actually visited this issue in terms of cell phone tracking. In that case, the question is that you have a cell phone, you've obviously consented to the GPS tracking, and those GPS tracking with the cell phone can ping off of many towers, and we can really find out where anybody is gone for any length of time just by following the cell phones. But the court declined to extend that consent that was given in when you give up your right, when you turn over and say to a cell phone carrier, yes, go ahead, you can use my GPS. And they declined to extend it and said that it's only for a limited time that your whereabouts can be tracked by the cell phone. So it is still very much a case-by-case basis. And so we have to stay in this kind of arena of reasonable. The last thing I want to touch on before I turn it over to Ian is what happens to persons who have been convicted and are either on probation or parole, meaning that they've completed their sentences and they're now free, but they're still under on probation or parole, and therefore under the authority of some law enforcement agency, and also those who are still incarcerated. In terms of persons who are on probation and parole, in California at least, pretty much 100% of the time, one of the terms and conditions is that you give up your right to be free from search and seizure at any time. Therefore, you do have a diminished expectation of privacy. In terms of persons who are incarcerated in a prison or a jail, that too is also very, those are very state specific, because each state will have their own set of laws and regulations that apply to and discuss how they handle privacy. For example, in the California correctional system, we have Title 15 regulations that govern how information or any documents pertaining to any inmate are distributed. And there is a section that says we will not give out any information on an inmate unless one of these criteria met. It's for litigation, there's a subpoena of some sort, and they certainly will not just turn over that information to any member of the public. So those are all going to be more state specific. So as we're moving along, and as we're trying to see how any AI that we come up with and some of the solutions that Ian and William are going to talk about, that it certainly should be in the back of our minds as to what are the privacy interests and how are they being handled in the various states where this technology may be utilized. And with that, I'll turn that over to Ian.
Actually, I just wanted to jump in. You made a very interesting point there, is that when data from a government agency would be used, we have to take certain measures to protect those persons, the privacy of those persons. So, and that could be, I know, Will, you may want to touch upon this, with some specifics, but that could be masking their identifiable characteristics like their name, their social security number, any sort of demographic information, and translating it into some sort of code so that at least that event or instance can be used, but you're not letting demographic information get in there. Will, what do you? I know that you specifically deal with this issue.
Yeah, absolutely. And good afternoon, everybody. I hope you're all doing well. So, privacy, it's a big issue, right? It's something that, on the prosecutorial side, even though we're prosecuting someone, we still respect their right to privacy. And when we work with various research partners and we try to, as an organization, get better, that involves, sharing information. And so one of the things that we'll typically do when we have a case, we assign a person ID to someone. It's a number that, we're the only ones who hold the key between the person ID and who that person is. And so what we'll typically do is remove anything that could possibly identify that person and use a person ID. And so that way, as a research group, what you can do is you can then see, okay, this person ID had, then maybe they were convicted of this crime or that crime or what have you. And this was the sentence, right? So it's super important to us.
Mm-hmm. Mm-hmm. But I'd like to turn back to Ian to introduce some of the ways that AI is actually being used right now. So Ian, could you touch upon that topic?
Yeah, I'd love to. So I'll kind of start out real briefly. AI is currently used by law enforcement agencies in a number of different ways, really three primary ways. There's location identification, which can be heat maps of where crimes have occurred in the past, suspect identification, which can be as advanced as facial recognition software, and we can talk about all the flaws involved in that as well. And then also victim identification. A lot of times this is for vulnerable populations such as like elder abuse and things of that nature. You can identify potentially vulnerable individuals and intervene to avoid a crime from being committed. But there's also more specific uses on the DA side, as kind of Will was alluding to as well. A lot of it has to do with research and investigations. Just like Preeti was referencing particular cases like Katz or Griswold v. Connecticut, there are natural language processing algorithms that can crawl through court cases and create summaries on their own, that reduces the time that actual attorneys have to do a lot of that legwork on research. And there's also even simple applications of cluster models that can sift through lots of financial data to identify fraud, much in the same way that your credit card company will flag a charge that they think could be fraudulent. A lot of economic crime units can do the same thing for searching for potential crimes in those as well.
And you were saying that, let me see here. Under investigative research, I know there's simple fraud detection or pattern recognition, but also what are some of the more complex models that the DA's offices are using, and maybe like where are they getting that data? Is it all proprietary, just their own data that they've collected from incidences and police incidences?
So yeah, some of it is our own data that we've collected from law enforcement agencies. A lot of it also is these large repositories from things like Westlaw that have access to many different cases that could be similar and have similar charges. And that kind of leads into some of the problems and complexities with that. And I think our original speaker, Marie Wallace, touched on some of that some of the problems are institutional and legal rather than technical. And a lot of that has to do with the access to some of this data, because there is this kind of paywall of being able to access what is technically public domain of a lot of these court cases. Some courts are charging as much as 10 cents per page for court documents, even though they're considered public domain. And that is very prohibitive for any kind of third-party solution or startups to actually go in and make sense of this data and help optimize these systems. And then there was another point that was brought up earlier in the discussion today about a lot of the natural language processing algorithms being in English primarily, and that causes problems for minorities and other institutions that may not have English as a first language. And then also, I'll just bring up really quick another issue that's big is the fact that not all of the charging language is as universal as we would expect and think. So I live in California. We're currently working on a master charge code for the state of California, but right now it can vary from jurisdiction to jurisdiction, which means that if you're charged with a particular crime in San Luis Obispo County, for example, it may not be the same as crime code is in Yolo County, and to marry those two data sets together and make sure that they're representing the same information is very difficult for data scientists, because you're going to have to first match things together that aren't necessarily the same thing.
That's a very interesting. Will, I know that you have specific experience working along the lines of the topic of recidivism. And do you have those issues where data standardization tends to be an issue, or what are some of the challenges that you have there?
Yeah,
and also,
certainly.
What are you actually looking to get out of using AI in terms of with recidivism?
Yeah, thank you. We certainly have issues with data standards. I know that master charge project, that's been going on for years, right? The team has been working towards this goal. It's super complex. So, in our county, which is again here in California, there's a couple of things that we're really sensitive to, right? So just as, let me start by saying our prosecutors go through an unconscious bias training. And I think that is a really good foundation, because as we're talking about AI, we're talking about recidivism. One of the things that, for the people who are on the line, if you've ever read the book, Weapons of Math Destruction, one of the things that we want to be super, cognizant of is that we're not taking unconscious bias that we may have as individuals, building that into an AI model and then applying it towards people who need as much help as they can get, right? So, just as a defendant has a heartbeat, the prosecutor has to have a heartbeat as well. And so these, AI technologies and algorithms, they need to support the process, but ultimately, the prosecutor needs to be making, the decision at the end of the day based on the facts of the case.
Right. Yeah. I just wanted to interject one little thing. You make a very important point there of using AI as a supplement to the decision that the DA is making. And that's a very important point, because one of the common themes that we've been already going through in this summit that we're having is the topic of accountability. If you're having the decision maker be an AI system, it makes it a lot easier to pass that accountability off. Whereas if the DA is still making the decision and he's using the outcome of AI to help with his decision, he still has to be accountable. Is that right?
Yeah, absolutely. And I wish I could say that we were as advanced as it relates to AI and criminal justice as AI is with the battle against cancer, but we're just not. In fact, we're far behind, and we need as much help as we can get. We have a huge issue, as you mentioned, with data and how it's the various kind of information that we get. It's different every single time. You could have 3 defendants who are all accused of committing the same crime, and each one of them has a different story. One may have mental health issues. One may have a drug, issue. Another person may be, in sudden poverty, right? Could be poverty against all three. And so these AI models that we're discussing have to be smart enough to look at the person's background to, whatever extent is possible, and then make suggestions to that prosecutor about what would drive the most positive outcome. Because at the end of the day, we want to get this person out of the criminal justice system. We don't want to see them, back in it, right?
Right. And this actually, I know that we're running pretty much to our time, but if we can get to the last slide, which talks about, Ian, you may want to touch upon some of the challenges that you as well as will have faced with implementing the AI systems in the criminal justice arena.
Sure. And first quote, garbage in, garbage out. I think we all know that one pretty well. The quality of the data that we're using is questionable at times, and using historic data can also perpetuate historic biases. So we want to be very conscious of that moving forward and utilizing these tools. Will touched on identifying the root cause. I think is really critical. That's an important part that I don't think is we're putting enough emphasis on in general. And while it's difficult to identify true root cause, I think that should be the goal of a lot of these systems. And then I talked a little bit earlier about the problems with access to data and the standardization across jurisdictions, because I think that's a primary block to a lot of these being viable, really. And there is work being done on it, but it is historically a very difficult world to kind of break into, and I don't see that necessarily going away without substantial changes into things like law.
Right. So I know that we're pretty much out of time here. I know this session was it almost seems like the whole session was a bit of a primer onto the subject of AI and criminal justice. So if anybody has any questions or follow-up questions, feel free to contact me or any of the panelists via LinkedIn or through the chat and the groups on Data Ethics for All. I thank you very much. Thank you to all the panelists and Shilpi for putting this together, and I hope everybody got something great out of it, because I certainly did. Thank you.
Thanks, everybody.
Thank you.
Thank you, Sanjeev. Thanks, panelists, Ian, Joe, William, Preeti. This was an awesome discussion. Thank you for tuning in. Take care. Bye-bye.
Bye.